express, and the state is saying that the motion to suppress, there was a search and it was a warrantless search. State, do you stipulate that this was warrantless?
Judge, I do so stipulate.
All right, then state, call your witness.
Judge, we call Deputy Trevino to the stand.
Oh, just sit here.
Okay.
You're welcome. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Just make sure you keep your voice up so everyone can hear, and if you could state your name for the record.
Yes, ma'am. My name is Deputy Rogelio Trevino.
All right, state, you may proceed.
Thank you, Judge. Good morning, Deputy.
Morning.
How are you doing today?
Doing good, doing good.
Right. So you state your name for the record. How are you currently employed, sir?
I'm currently employed with the Bexar County Sheriff's Office.
Okay. How long have you been employed by the Bexar County Sheriff's Office?
Right now, it's about 5.5 years.
Okay. Can you walk us through real quick, what kind of training regimens have you received or continuing law enforcement education have you received while with the Bexar County Sheriff's Office?
Regarding like the training academy.
Yeah, like have you done like DWI, SFST certification, tactics, investigatory techniques, crime scene investigation, things like that?
Yes, yeah, I've done crime scene investigation, and then also I've done DWI, where I've gotten certified.
Oh, okay.
Like the DWIs.
Are you also a what's called a field training officer?
Yes, yes, sir.
Field training officer.
So pretty much what a field training officer is, they will assign me a deputy fresh out of the academy, and then I'll have him for a phase, and then pretty much I have to document. We'll handle all different types of calls for service, and then I'll pretty much grade him, or also train him up, so he moves on to the next phase, and then pass him if he passes, or fail him if he fails.
Okay.
That's pretty much it.
Are these FTO spots usually reserved only for experienced law enforcement officers?
If I'm correct, yes. Yes, sir.
And you said, were you SFST practitioner certified in April of 2025?
Yes, sir.
Okay. So let's go to April 28th, 2025. Were you dispatched to a call at 11811 Petrenko Road?
Yes, sir.
Okay, is that the Las Palapas over there?
Yes, sir.
Okay. Now, do you remember the details of the call perfectly?
Yes, sir. Yeah.
Did you put notes in? Did you put notes into the CAD regarding your call?
Okay. Well, as we were going to the call?
Yes, sir.
No, we didn't put any going to the call.
Did you put notes in during the call?
Yes.
Okay. Did you write a report on this?
Yes, sir.
Would a copy of those notes in that report help refresh your recollection for testimony today?
Yes, sir. Yeah.
Okay.
No objections to states 1 or 2.
May I approach?
All right, you're not, are you admitting it, or are you just?
No, just to refresh the recollection of the witness.
All right, so yes, you may approach the witness with States Exhibits 1 and States Exhibit number 2. And is 1 and 2 both his reports, or what is 1?
It's a report packet as well as the CAD notes.
Okay, which is which?
Oh, State Exhibit 1 is the CAD notes.
Okay,
And State Exhibit 2 is the report.
all right, thank you.
So since these have not been admitted into evidence, don't read directly off of them. But if I ask you a question that you don't know the answer to, feel free to read them, refresh your memory, and then you can testify from your memory.
Okay.
Sound
Yes,
good?
sir.
Good. What was the nature of the call you were dispatched to?
It was for it was a call for service for a vehicle that was stopped in the drive-thru, and there was a male asleep inside of the vehicle.
Okay. Was there a description of the vehicle?
Yes, it was a white SUV.
Was there a license plate that was included in the description?
If may I look at my report?
You may. That's what they're there for.
All right, perfect. Yes, the license plate was reported from dispatch.
Okay.
On
What
the
was,
CAD notes.
okay. So it was a white SUV. What was the license plate?
It was
Okay. And the report was there was a male asleep behind the wheel?
yes.
Okay. Were there any other notes there, like he was asleep in the driveway?
Yes, it said that he was asleep in the drive-thru for roughly about 15 minutes.
Okay. Were other vehicles having to take some kind of action?
Yes, they were having to drive around him.
Okay, all right. So when you and, was it you and another deputy or were you by yourself?
Yes, it was me and another deputy. He was in training,
Okay.
Deputy Alexander Casanera.
Okay. So were you training Castaneda that night?
Yes, I was.
Okay. So when
Judge
Stopwatch
Boyd
clip one.
immediately denied the
Insert
motion
at
to
6
suppress.
o'clock.
As of the date of
Police
writing this
Starlight
episode, the
welfare
felony
check
possession
or
case
criminal
remains pending and
investigation.
is set for jury
A sleeping
trial on
driver
July
seemed
21st,
harmless
2026.
until
And the
deputies
driving while
spotted clues
intoxicated
that
and unlawful
changed
carrying of a
everything.
weapon charges
Would you
are set for
expect
jury
a
trial
welfare
on
check to
August
end in
11th,
handcuffs?
2026.
Viewers
This
will be
hearing
stunned.
illustrates.
And then I had noticed the same license plate. I was like, hey, there's the vehicle. So we stopped, and then that's when we saw that vehicle.
Okay, where was the vehicle when you first saw it?
It was in the drive-thru, directly in front of the, I guess you want to say, the drive-thru station.
Okay. When y'all approached the vehicle, what did you observe inside?
So I approached from the passenger side, and when I approached from the passenger side, I saw the male inside of the vehicle. He was awake, and then I could also see, like, I could see, like, I think, like a can sitting right there in the what is it, in the center console, in the cup holder. And that's pretty much it upon making contact initially.
Okay. So at this point, the call was basically a welfare check.
Yes, sir.
At this point, did you have any reasonable suspicion that offense had occurred or was occurring?
So initially, as the window was rolled up, right, when I got up to that passenger side window, I asked, I was like, hey, roll down the window. And as we rolled down the,
Asked, right?
yes, yeah, as we asked to roll down the window, or I asked specifically, this is when I could smell the odor of alcoholic beverage coming from out of the vehicle. Yeah, that's pretty much what I smelled.
Deputy Trevino testifies that the call began as a welfare check and that he developed suspicion of driving while intoxicated when he smelled the odor of an alcoholic beverage after Mr. Zamaripa rolled down his window. In the 1973 case of Katie v. Dombrowski, the Supreme Court upheld the warrantless search of a disabled vehicle and, in doing so, recognized that a police officer's job involves duties beyond gathering evidence, enforcing the law, and investigating crime, characterizing those duties as community caretaking functions that are quote-unquote totally divorced from the detection, investigation, or acquisition of evidence relating to the violation of a criminal statute. So-called welfare checks typically fall into this category of police functions. Now, the Court of Criminal Appeals of Texas applied the community caretaking doctrine to seizures of individuals in the 1999 case of Wright v. State, holding that even without reasonable suspicion or probable cause, an officer may, as part of their duty to serve and protect, stop and assist an individual whom a reasonable person, given the totality of the circumstances, would believe is in need of help. However, the fact that a citizen contact began as a welfare check rather than a criminal investigation does not require an officer to act solely in a caretaking role, as observations made during the encounter, such as the odor of an alcoholic beverage or an open container in plain view, can supply reasonable suspicion that criminal activity is afoot, transforming the caretaking encounter into an investigative detention. This is the sequence that Deputy Trevino described here, testifying that the smell of alcohol coming from the vehicle marked the point at which the deputies began to suspect an offense.
Okay. Did you and Castaneda have a hand signal to show that, hey, there was the odor of intoxicants that was smelled?
Yes, from what I recall, I remember as he rolled down the window, me and Castaneda looked up at each other over the vehicle, and that's when he kind of was like, hey, there's, like, it smells in here. And we pretty much we didn't say anything, but we were kind of leaning more towards like, hey, there's something going on here.
Okay. And was this when you started to reasonably suspect that an offense was occurring?
Yes, yeah, we were at that point. Once he gave me the hand signal, I had already smelled the odor of alcoholic beverage, and then from him telling me with his hand, that's when I was starting to think, hey, he's possibly under the influence of alcoholic beverage while in the vehicle.
Okay. And is this when y'all asked Mr. Zamaripa to step out of the vehicle?
Yes, sir.
Let me ask you, Mr. Zamaripa, would you recognize him if he was in the courtroom right now?
Yes, sir.
Is he in the courtroom right now?
Yes, sir.
Can you point him out for the judge?
He's sitting right there with that aqua and white shirt.
Okay. Let the record reflect that the witness has identified the defendant.
Rates that
Stopwatch
the
clip
community
2.
caretaking
Insert at
doctrine,
10
although
o'clock.
designed to
Balance
authorize
scale, one
assistance
smell
rather than
changed the
enforcement,
entire
can
case.
become the point
odor
of
of
entry
alcohol
for a criminal
transformed a
prosecution against the
routine
very
welfare
person it
check
was
into a
invoked to help. The
DWI
doctrine exists
investigation.
because
Was
officers
this
are
smart
expected to do
policing or
more
a
than investigate
constitutional
crime,
gray
and a
area?
rule
What do you
forbidding
think?
every unrequited.
Did Officer Deputy Castaneda start doing what's called SFSTs?
Yes, yeah. He started conducting the standardized field sobriety tests.
Oh, okay. Did you observe any clues during the SFSTs?
Yes, yes, we did.
Did you observe enough clues that you had probable cause to make an arrest?
Yes, sir. Yes, we did.
Did yourself and Deputy Castaneda make an arrest?
Yes, we did.
What was the events that y'all arrested Mr. Enrico for?
We arrested him for the driving while intoxicated, the unlawful carry, and then when we got to the jail, we located a bag of cocaine inside of his wallet, and so we also arrested him for the possession of cocaine.
Now, the bag of cocaine was found after the arrest, right?
Yes, yes, sir.
Is it the Berry County Sheriff's Office standard procedure to search prisoners before entering the South Tower?
Yes, yes, sir.
And is that when it was found?
Yes, yes, it was.
Following the state's questioning of Deputy Trevino, the deputy's body camera footage is admitted into evidence and published in the courtroom. The footage showed the deputies contacting Mr. Zamaripa at the drive-thru, questioning him about his drinking, and administering the standardized field sobriety tests before placing him under arrest. When the footage concluded, Mr. De La Paz began his cross-examination of Deputy Trevino.
Hi, good morning, officer. Couple of quick questions. Do you remember when you first got some questions about the training and DWI? Do you remember that portion?
Yes, sir.
Okay. Now, this is a welfare check, right?
Yes, sir.
Okay. So you get a call from dispatch, right?
Yes, sir.
Hey, can you go check out this person, correct?
Yes, sir.
There's no call to EMS, right?
No, sir. There was no EMS.
You yourself did not call EMS, correct?
No, sir.
None of the officers that were with you called EMS.
No, sir.
Okay. The place that you went to is a restaurant, correct?
Yes, sir.
It's open, right?
Yes, sir. It's open.
Okay. When you get there, the call was for somebody sleeping in the drive-thru line, right?
Yes, sir.
Sleeping is not a crime in the state of Texas, correct?
No, sir.
Sleeping in your car is not a crime in the state of Texas, correct?
No, sir.
Now, when you get there, you don't find anybody asleep, right?
No, sir.
But you went to the vehicle with the license plate that you're given, correct?
Yes, sir.
We saw him on the video, right?
Yes, sir.
He's wide awake, right?
Yes, sir.
And you didn't have any problem talking to him?
No problem talking to
I mean, you understood him, right?
him. Yes.
He understood your questions, right?
Yes, sir.
He responded to everything you said, right?
Mm-hmm.
Fully alert, right?
Mm-hmm.
Now, he himself is not saying, "Man, I'm so glad you came. Let me tell you, I think I'm having a heart issue." He didn't say anything like that, right?
No, sir. He didn't.
He didn't say, "Man, I'm having cramps in my legs. Can you help me out?" Right?
No, sir.
No level of distress, correct?
At that point, no.
And the restaurant had employees in there?
That I don't remember. I mean, I think it was open. So yeah. I mean, yeah.
There's other cars in the drive-thru?
Yes, sir.
He had access to anybody else if he needed it, right?
Yes, sir.
And so he was alone in his car, right?
Yes, sir.
But he could have reached out to anybody. He could have honked his horn, right?
Yes, sir.
Could have called 911, right?
Yes, sir.
Y'all got there relatively fast, right?
Yeah, relatively, yes, sir.
Okay. Can't say that he was a danger to himself, right?
At the point of making initial contact, I can't say that. No.
I mean, he wasn't a danger to anybody else either, right?
No.
And we'll agree that there was no traffic stop here, right?
No, sir.
Now after you talk to him, there's an order for him to get out of the car, right?
Yeah, we asked him to get out of the car.
I mean, do you ask him or do you tell him? You give him a command?
It was more like I asked him to shut off the vehicle and
Oh.
step out of the vehicle.
So he could have told you, "Hey, give me your number, I'll call you later," right?
He could have.
And so you would have just let him drive off, right?
Well, based off of what we saw, once we asked him, the reason for us asking him to step out of the vehicle that's why we asked him to step out of the vehicle. We observed the open container and we smelled the odor of alcoholic beverage. So
So your
I
answer,
wouldn't have at that point.
your answer is he could not have driven off.
He could not, no,
Okay. Because there was an order from you that he could not leave.
based off of observing the offense. Yes, sir.
Now, we saw you tell him to turn off the vehicle, right?
Yes, sir.
And then he's out of the vehicle. It's two officers surrounding him, right?
Yes, sir. We were on both sides of the vehicle.
He's trapped between you two and his vehicle, right?
I don't know if you could use the word trapped, but I mean, I would say no, he wasn't trapped. We weren't holding him down or anything like that.
You know what the word trap means, right?
I would think it's like you catch somebody or something, right? And you like hold it there or hold that thing there.
So did you both prevent and did you stand in front of him in such a way that he would have not been able to leave without having to move one of you two?
I guess, yeah, I guess you could say that.
Now, I don't know if you saw it. You wanted him to move in front of the car. You remember that?
What was that?
Sir? You wanted him to move in front of the car. You remember that?
Yes, at the point of observing the offense, yes, we asked him to go over to our vehicle, in front of our vehicle.
And was that your hand that pushed him forward?
If I'm correct, I didn't push him. I think I might have guided, like I was like, hey, let's go over here.
Did you make contact with him?
That's a hard one to remember. I don't remember if I even touched him. I think I remember guiding him. I was like, hey, sir, step over here for us. But I don't remember touching him. I can't recall that part.
So this is also a command that you've given him, correct?
Yes, after observing the offense, yes, sir.
This is also a command that he followed, correct?
Yes, sir.
Command that he didn't have any problem understanding, correct?
No.
But he could not at that point say, hey, I don't feel comfortable. I gotta go.
That I don't know what he was feeling, so I can't really say what he was feeling.
Let me ask you a quick question. You understand as an officer, how you said you had 5 years?
5.5 years, yes, sir.
You understand there's a difference between checking on somebody's well-being and investigating a crime, correct?
Yes, sir, yes.
And they gave you training on laws, right?
On the Texas Penal Code, yes.
Okay. And y'all actually, like an in-service, y'all actually go over rulings from courts and how y'all can use those and or not use them, right?
There is some court cases, and then there's some I guess you want to say like offenses that they go over, yeah.
And this was the other officer was with you was a training officer.
Yes, sir.
Or trainee, I'm sorry.
Yes.
Okay. You were training him.
Yes, sir.
Now let me ask you something real quick before we move on too much. You've agreed with me that this is initially a call for somebody sleeping in their car, right?
Yes, sir.
You understand what Miranda rights are, right?
Yes, sir.
Okay. You understand that gives a person the ability to answer questions or not answer questions, correct?
Yes, sir.
You do tell them, hey, if you are going to answer me, I'm going to use those answers against you, right?
Yes, sir.
We can agree that nowhere on this video are any of those rights given, correct?
No, sir. Yeah.
Okay. But you did ask him about drinking, right?
Yes, sir.
You did ask him the time of the drink, right?
Yes, sir.
You asked him what kind of drinks, right?
Yes, sir.
Those did go into a report, right?
Yes.
Those answers are being used against him, right?
Yes, sir.
You did come in here with the intention of testifying that you arrested him for DWI, correct?
Yes, sir.
But he was never given those rights, correct?
No, not at the time when we were investigating. No, sir.
But those are things that are used against him, correct?
Yes, sir.
Mr. De La Paz questions Deputy Trevino about whether Mr. Zamaripa was ever read his Miranda rights, establishing that no warnings were given even though the deputies asked Mr. Zamaripa about his drinking, and his answers were then documented in a report and used against him. In the 1966 case of Miranda v. Arizona, the United States Supreme Court held that before an individual in custody may be interrogated, they must be advised of their right to remain silent and their right to counsel. However, this obligation attaches only to custodial interrogation, meaning questioning initiated by law enforcement after an individual has been taken into custody or otherwise deprived of their freedom of action in a significant way. The Supreme Court addressed how those principles apply to traffic investigations in the 1984 case of Berkmer v. McCarty, holding that while Miranda protections extend to custodial interrogation for any offense, regardless of its severity, roadside questioning of a motorist detained pursuant to an ordinary traffic stop is not custodial interrogation, because such detentions are presumptively temporary and brief, making them more analogous to an investigative stop than to a formal arrest. Under the Berkmer case, an officer may ask a detained driver a moderate number of questions to confirm or dispel their suspicions without administering warnings, and Miranda rights are required only when the individual's freedom of action is curtailed to a degree associated with formal arrest. The absence of warnings during a temporary roadside investigation therefore does not by itself render pre-arrest statements inadmissible, and thus it is unlikely that any statements that Mr. Zamarripa made to the deputies during this period could be suppressed on this basis.
We saw the field sobriety testing, and your trainee is the one that we see marking.
Officers are expected to do more than investigate crime, and a rule forbidding every unrequested check on a motionless driver would leave genuinely endangered people without aid. An officer who approaches a vehicle to ask whether its occupant needs help, however, arrives with the authority and the duty.
Field sobriety testing, correct?
Based off of, looking at the field sobriety test with the training, Deputy Castaneda at that time, yes.
So it would be your testimony that he failed those field sobriety tests, correct?
I would say that there was clues. There was clues that would indicate that he was under the influence.
He gave a breath test later,
If I'm correct, yes.
and it was 0.05, right?
I'm not sure what the actual percentage was.
It was well under the 0.08, correct?
Okay. Yeah, I'm not sure. I'm really not sure, sir.
Did you prepare the warrant?
The warrant, yes, the warrant I did. Yes.
Now, in the warrant, there's language in there that says, well, let me ask you this. That document is sworn to, right?
Yes, sir.
Okay. In that document, it says that the defendant tried to conceal his blood alcohol. Remember that?
Let me take a look. May I look at my report?
Judge, I would object to that. Defense counsel is asking a witness to reference a document that's not in evidence.
Right, that'll be sustained.
I'm sorry, Your Honor, I thought it was. If I can get a copy of it.
Let me get you.
Yeah, if you don't have way out. My apologies, Judge. I thought that was part of states 1 and 2.
All right, and Deputy Laura, can you see if all of the jurors are here?
Can I virtual witness real quick?
Sure.
Which one?
All right. Deputy, I'm gonna hand you what's been marked as defendants, these are the one, not states. And you said this was the warrant that you prepared, is that right?
If I'm correct, yes. Can I take a look at it?
Sure.
I think I assisted Alexander Castaneda in preparing this warrant. If I'm correct, yeah. Because his name is on it.
And the Deputy Castaneda is the trainee?
Yes.
You reviewed this?
This right here before I submitted it, before we submitted it, if I'm correct, yes.
Everything else is a standard, right?
What do you mean?
The language is standard and everything else, correct?
Can you explain what you mean?
In other words, let me draw your attention here. On the very first thing, affidavit for search warrant and magistration, that's pre-printed, correct?
Yes.
State of Texas, County of Bear, that's pre-printed, right?
Yes.
Number 1 is there is in Bear County, Texas, and it keeps going. That's pre-printed, right?
Okay. Yes, sir. So you're saying that like the actual warrant?
Yes, sir.
You're asking if it's printed form?
Yes.
Yes. Yeah. The whole warrant is printed, right? It's already like pretty much created. And then what we do is we fill in all of the information that we have, and then we give our reason behind why we want the search warrant or the blood warrant, and then we go get it signed by the judge, and that's pretty much it.
Okay. Can you read out loud number 2?
It says the suspect is presently in custody of a law enforcement agency, namely the Bear County Sheriff's Office, which will present the suspect to execute the warrant requested herein.
And then can you read for me number 3?
Mm. The suspect has possession of and is concealing human blood, which constitutes evidence that the suspect committed the offense described in paragraph 4 below.
To
Stopwatch
act
clip
on
4.
what they lawfully
Insert
observe
Act
once they are
2020.
there. And nothing in the
Oncoming police
doctrine
car, no
requires
Miranda
them to
warning, but
ignore
can
evidence
statements
of an
still be
offense that
used?
comes into plain
US
view
law
during the
draws a
encounter.
critical
For the
line between
public, the
temporary
consequence
detention
is that a
and
call
custody.
requesting a
Would you
welfare
know
check
your
summons a
rights in this
police
moment?
officer. And everything
Many
that
viewers
officer
won't.
sees.
Would you agree that he concealed his blood the way that it's presented there? Let me back up.
He refused, yes. If I'm correct, he refused to provide his blood specimen.
Okay, but he already had a breath sample, correct?
Yes,
And so you just somebody wanted to get his blood, right?
yes, sir, because we found the cocaine as well.
Even though he blew under, you still wanted to search his blood, right?
Yes, because,
Hang on, time out.
okay,
You didn't have any reason at that point to search his blood, correct?
yes,
Time out. Did you conduct a DRE test on him?
no,
You had no basis for doing it other than possession, correct?
yes, sir.
You had no basis to believe that he actually was using cocaine at that time, correct?
Do I have, can you repeat the question?
You had no basis to believe he was using cocaine at that time, correct?
Yes, possibly I did, because he had it on him.
Okay, okay, he had it on him. There are people in your 5.5 years that you've arrested that were not using, but in possession, correct?
That I can answer.
So then it's a guess, correct?
Yes, yeah,
So you're guessing that maybe he might have it in the system, correct?
it was possible, yes, sir.
Okay, but that's not the standard for that warrant, correct?
The standard,
In other words, you would have had to have known it was in his system, correct?
All right, let me ask a question. So in this court, what you're seeking to suppress is the possession of drugs, or are we here for a DWI?
Well, Your Honor, I didn't want to waive anything, but I will be happy to move on regarding the issue that I filed the motion for.
All right, because if it's for the DWI, that needs to be in misdemeanor court. I'm only here to determine, I believe, whether or not this officer had the right to investigate this call that he received, which I'm assuming is under his caretaking duties related to the community. And then from there, this is alleged to have led to a possession of drugs, which is what we're here for. Is that correct?
That's correct.
Yes, Your Honor.
All right, so if we could get to that point,
Thank you.
please.
All right, let's recap real quick. Not illegal to sleep in your car, correct?
no, sir.
Not illegal to sleep at all, correct?
No, sir.
There was no level of distress at all that you saw from Samuel.
No, sir.
And he's in a well-lit place, right?
Yes, sir.
Plenty of people around.
Yes,
Somebody else, if he really needed assistance, could have given it to him, right?
yes, sir.
And sitting in the car, he's not a danger to himself.
No, sir.
Sitting in his car in the drive-thru line, he's not a danger to anybody else.
No, sir.
That's witness.
All right, thank you.
No further questions, Judge.
Is this witness excused?
By the state, Judge, yes.
Yes, Your Honor.
Both sides and everything that officer sees, smells, and hears after arriving can become
Stopwatch
evidence in a
clip 5.
future criminal
Insert
prosecution,
at
meaning that the subject of a welfare
27:45.
check can
Collision
leave the
judge
encounter
rejects
in
the suppression
handcuffs,
motion.
even though
A simple
nobody
welfare
suspected them
check
of a
became
crime
the
when the
gateway
call was
to felony
placed. Let us know
charges.
if there is a case or
Is the
courtroom
community